News that impacts you and your community. 13 on Your Side Evening Plus starts now.
Good evening, everyone, and welcome into Evening Plus. I'm Julia Gorman, joined by Lauren Baker and Josh Albertus, and we also have our Callie Lichter live from the courthouse. We are continuing to recap for you here on Evening Plus what exactly happened in the trial of Christopher Schurr, which continued for a third day today. So I first kind of want to summarize what we saw happen, because it was kind of a lot. We heard from several people. We also saw some motions filed that were ultimately denied by the judge. So we're going to break all of that down, and we're all kind of going to interject here, guys, whenever you feel you have something that you want to add. Callie, that includes you. So first we heard from Nicholas Bloomfield. He was the use of force expert. He started at the end of yesterday and then continued into today. His testimony continued for quite a while. Here is him on the stand. We're going to hear a little bit from his testimony, but guys, we once again really heard him kind of talking about exactly what he's an expert in, which is use of force and how that relates to what we saw happen in the situation between former Officer Schurr and Patrick Loyola. Any highlights that stood out to you guys in regards to his testimony?
I think the biggest thing is that we kind of saw a back and forth during his testimony today, because the defense was actively trying to put in evidence into the case. Essentially, they were having him slow down, and they were taking screenshots of what they were talking about to kind of expand what people were seeing, and ultimately the prosecution objected that, saying that it was wasting their time, and the judge actually ruled in favor. And so, just to clarify, they can still do that process. They can still bring him back. They can still go through the pictures they want to expand and bring that back to the jury. They just couldn't do it right then and there. And we talked to experts who said that that's typical. You see that often. You see people who will maybe bring a picture up and circle something, or point something out. So what he did wasn't wrong, or what the defense did wasn't wrong. They just ultimately said it was just taking too much time, especially because it was on video that we had already seen. Right,
video that of course has been brought up many, many times. And one of the topics that was discussed was weapon retention, which was basically described as police officers here in Grand Rapids, across the country, go through training where they're always aware of the weapons that they have on them, the taser, a gun, a baton, what have you, and making sure that they are in control of those. And when they are interacting with a subject, for example, in the case of Schurr and Loyola, there was a lot of questions surrounding, making sure you're secure. Obviously, the taser is the weapon in question as far as that being used. What was Loyola's relationship with touching that taser during that struggle? So that was brought up, and we do have a bit of testimony on that topic that we can play first for you.
So it's generally accepted in policing all across the country. The principle of what we refer to as weapon retention, where officers are taught tactics to retain their weapons, essentially to keep other persons from grabbing and getting a hold of their weapons and potentially using those weapons against either the officer or other bystanders. So this is a heavy part primarily of defensive tactics training that officers go through, both the basic training as well as they go through refresher trainings throughout their career. And so extending a tool in close proximity to an individual, especially one that is facing you in this manner, creates a high likelihood that your weapon is likely to be grabbed, or your tool is likely to be grabbed in this particular instance. What we see a lot of times, and again, this is not just related to tasers, this could be firearms, batons, OC spray, is that when it's in close proximity, you will have subjects who will reach out and attempt to either deflect or disarm officers, just because the opportunity is there, even if prior to that there was no indication that an individual was attempting to close distance and disarm an officer. It's more opportunistic in a lot of these cases.
And I want to jump in just very quickly. I jumped ahead of myself thinking that was the next person we're going to hear from.
Yeah.
So what I said did happen, but not with that witness, just so
Yes.
people are aware.
Yeah, absolutely.
But I think it's important to note just how much Mr. Bloomfield's testimony was such an object of contention when it comes to the contention between the prosecution and the defense. He was one of the two witnesses that actually, as you were talking about, requests that were made by the defense today. One of them was to call a mistrial. Basically, in essence, it's arguing the trial has been so tainted by something that it can no longer be fair, and we have to stop the trial. We have to, in many cases, come back with a new trial. It can be a new jury to ensure fairness. And what the defense was essentially saying, in the words of one of those defense attorneys, basically saying they were opining on standards that are not applicable under Michigan law, that of course former Officer Schurr would have been subject to as a police officer in the city of Grand Rapids. So it's just important to mention how much his testimony and the Mr. Stoughton's from yesterday, the other use of force expert, was such a contention there that it actually led to that request for an actual mistrial in this case. We could have seen this trial just come to a stop today,
right,
if the judge had accepted that.
Which would have been a huge deal. And we're going to hear from one of our legal experts in just a moment. I just wanted to bring up as well that the piece of testimony that you heard there, what kind of came after that from the prosecution was, when a police officer has their weapons and if they are using something, for example, the taser, there is that opportunity, for someone to grab something or take a hold of it. What was talked about after that by the prosecution and also Bloomfield once again was that the taser had already been deployed twice, and basically the point that was proven again by the prosecution was that even had Patrick Lua grabbed the taser in that moment, it really would not have been feasible for him to incapacitate former Officer Schurr in that moment, was the point that they proved after that piece of testimony. Callie, I don't want to leave you hanging out at the courthouse. Obviously we heard from Bloomfield yesterday, again today, and Josh kind of segued us into this motion of a mistrial and also directed verdict. You were in the courthouse all day long listening to all of this up close as well. Your thoughts on the beginning of testimony today?
I mean, I don't think it was, a random decision by the prosecution to end with both Stoughton and Bloomfield. I kind of think of them, they did that report together. It was a joint report that they did, on this case. They kind of go together. They were talking about similar things, but, like you guys mentioned back in the studio, they focused a lot today on that weapon. It was really the prosecution's last hammer home that there was truly other things that could have been done to make this shooting unreasonable. Like the shooting, they're trying to prove that there was other things they could have done, or that Schurr could have done, than just pull the trigger on that gun. And so I think really ending with that testimony that, there were other options out there. The taser wasn't going to incapacitate him, lead to neuromuscular incapacitation, NMI, which is what happens when you are, shot with the probes of a taser. And so I just think it was very powerful that that's what they ended on, obviously knowing that the defense was going to call a use of force expert on their own.
And we have a clip from exactly what you're talking about, sort of those powerful last moments of testimony with Nicholas Bloomfield. We can play that now, kind of honing that point home.
So with the taser, there's a theory that's commonly held within the policing industry with regard to an officer being disarmed of a taser. The theory essentially posits that an officer may be justified in using deadly force if they were disarmed of their taser because of a threat that they may have the taser used against them, specifically being incapacitated by the taser. In order for that to be a valid claim, the taser would have to be in a condition to where it could cause neuromuscular incapacitation. The greatest likelihood of neuromuscular incapacitation being achieved, as I've mentioned here on the stand multiple times, is through a probe deployment. The Taser 7 is equipped with two cartridges, and those cartridges are there because, again, over the years, the original tasers only had one cartridge. Then Taser started coming out, Axon started coming out with multi-cartridge models because, again, a lot of things have to go right in order for to have a good probe deployment and have neuromuscular incapacitation achieved. And so Taser started again coming out with multi-cartridge models to give officers follow-up opportunities in the event that they were unable or unsuccessful. And so there's only two cartridges available. Beyond that, when it comes to drive stun mode, even with the expanded cartridges, we're now in a situation where the taser can still be used in follow-up or drive stun mode. but that operates off the principle of pain compliance, so it does not achieve incapacitation. And so in this particular circumstance, you have a situation where a taser is no longer in a condition to where neuromuscular incapacitation is likely to be achieved, either against the suspect or against the officer in this particular case. And so based upon that, a reasonable officer in this position to elect to use deadly force, knowing that is the condition of the taser, that would be unreasonable, excessive, and contrary to generally accepted police practices.
Yeah, and that was sort of that pivotal moment of testimony there that, Callie, you were getting at, because that's the point that we're coming down to in this case, is proving if this was reasonable, what was done. We know what happened, we've seen it on video, but was it justified? Was it reasonable is the big point. We also heard the defense questioning Bloomfield before he wrapped up. Obviously, the words that you just heard, very privy to the case the prosecution is trying to make, that this was not reasonable, that this was not justified. And then I do just want to play one more piece of testimony from Bloomfield when he was being questioned by the defense, and where they were kind of trying to make the case that, okay, what was done, but what could have kind of been going on in Schurr's mental, state of mind. So we can play that now as well.
You also have stated that in stressful environments, human decision-making suffers. Officers may experience distorted sensory perceptions, including visual distortions, like tunnel vision, auditory distortions, which is auditory blunting, and temporal distortions, perceiving events as occurring more quickly or more slowly than they actually are. Is that
Yes.
a fair statement?
Yes, it is.
In fact, you said it right?
Mhm.
Yes?
Yes.
And so eventually we saw Bloomfield wrap up there. And I want to move on to talking about these motions that were filed. But any other thoughts, Lauren, on your end, just about, wrapping up Bloomfield this morning?
I think the biggest thing is that this was the calm before the storm. We
Yeah.
saw after this testimony and after a quick break, this is where things really gear up. You really start to see not only the prosecution rest its case and give the defense their chance, but also you really start to see the defense lay out their plans, not just for this trial, but if they do not receive the decision that they want, for an appeal to this whole situation.
Yeah, absolutely. And Josh, this is sort of what your story was based on this evening. We saw two motions filed by the defense, mistrial and also directed verdict. For folks who are not familiar with what that means, can you kind of walk us through, what is that? What do those things mean?
Yeah, in court today, as I mentioned kind of earlier, just a little recap, the request that was made in court today was surrounding a potential mistrial. They felt that when it came to those use of force experts' testimony, the trial that we have now has been tainted to a point that there is not that objective fairness anymore. That's the essence of calling for a mistrial, is that we stop this trial. We, in many cases, have to call a new jury so that fairness and integrity can be kept on the trial aspect. But then you had the actual motion that was filed when it came to what was the
directed verdict?
Directed verdict. Yes, that directed verdict, essentially what it means and what they were requesting there is that the judge herself, as the name suggests, directs a certain verdict. They were looking for an acquittal here based on this notion that, in their view, perhaps the prosecution hadn't gotten the establishment of facts to suggest that a reasonable jury, a reasonably minded jury, could find Schurr guilty when it comes to the justification aspect, whether the use of force was justified or not. That a reasonable jury, as the experts explained to me today, would not find, based on what the prosecution laid out here in their argument, that was not justified, that he was guilty. That could not be reached by a reasonable jury, and that's what they were arguing. So they wanted Judge Mims to direct that verdict of acquittal, and she denied that because she felt, in her view, that still a reasonable jury could possibly, not necessarily, that is not a surety by any means, but in her view, they could find that certain verdict when it came to justification. That was what they were asking for.
And you guys heard from one of our experts from Cooley Law, and we have a clip from her kind of talking about this and how this process works. We can play that now.
On cross-examination, the defense attorneys asked about this idea of auditory exclusion and tunnel vision, right? How things appear under the stress of imminent death or great bodily harm or a stressful situation, and how time seems to slow down. And I think after Andrew and I were done talking on the live stream, it occurred to me that maybe that's why the first expert witness the defense called was slowing down those videos, is so that they can pick up with that idea of auditory exclusion and tunnel vision. I don't know, but I think that's something we may want to look for.
And I think that's something important with this mistrial and directed verdict is that these experts knew this was coming. This is something that people, defenses or prosecution tend to do in cases like these, because it's not just about this trial, it's also about their appeal. When you go into the appeal process, what they say is that that's the chance for those appellate courts to see if there is any error. They can't find that error or talk about that error if you don't go through the right procedures to put those things into motion. And so I know a lot of people have wondered, okay, it seems like they're throwing out a lot of motions. Well, one, they're doing everything that they can to stop what they can in this case for their own case, but also two, putting into motion that there's like these bookmarks in places where they're saying this is an error or this wasn't right, so that way when the appellate courts go back and look and make their own decisions, they can say, well, they did call for that. Why wasn't that discussed, or why was that passed? So it's kind of like playing chess, let me move this piece so that way, even though if we don't get the decision for this trial, if there's another one that comes after this, we made the right move.
And that's what those experts kind of said to me, is that, especially when it came to the verdict motion that was filed, that could be used to preserve the issue for in the case of an appeal. If a conviction is reached, then that can be a factor in that appeal later on, as Lauren was just talking about there. But also what you heard there was a theory from one of those experts about that related to the witnesses that we heard from today. That expert witness, that use of force witness that you heard from there talked about, or was being asked about, potential perception differences that can happen to someone under that kind of potential stress, tunnel vision, distorted time. And so she was relating that to the first witness that the defense called up. He was a video analyst, and he played a lot of the video that we saw, like frame by frame in many of these instances. And then, as Lauren mentioned, you had the prosecution, object, saying, basically, what is the relevance of this to the court? And that was sustained. But what the expert there was getting at, when you were going frame by frame, even though there was an objection to that, that may have had a point to it, in terms of this may have been closer to what former Officer Schurr experienced when it comes to distorted time. If we're going frame by frame, we're going slower, of course. And so that may have perhaps factored into the testimony we heard from the use of force expert when it came to distortion of time and what Schurr may have experienced, closer to what Schurr may have experienced, in contrast to what we were hearing earlier.
And Lauren, you're obviously, I know both of you are watching this trial very closely. Callie, is in the media room in the courthouse, and Callie each day is putting together very detailed, time-coded notes of exactly what's happening at every minute and big moments that stand out. Callie, watching from the media room these motions filed and sort of the, contentious atmosphere surrounding them, what was your take on all of that and kind of how that ended up with, of course, the judge denying both of those motions?
I think it goes along with what I've been saying for the past couple of days and what we've been saying for the past couple of weeks. The defense has done everything they can and are continuing to do everything they can to try to, at first, not even get Stoughton and Bloomfield to be on that bench in the first place. And then, they were on the stand, and to not be on the stand. And so you saw that in some of the questions and the objections that they were making yesterday and some that were making today. And then you saw it with one of the defense's witnesses that they called in, their use of force expert, going, play by play of the video and having their use of force expert, well, I guess not a use of force expert, but GRPD policy expert, who kind of explained, how GRPD sees use of force. It's kind of their, at this point, rebuttal to those two experts. And so you're just seeing kind of a continuation on, trying to almost discredit these two witnesses. And I think that, trying to call a mistrial because it's too late into the trial to strike both Bloomfield and Stoughton was just another way of them trying to do that. And again, like it has been said, the defense is going to do everything that they can to, try to win this trial for defendant, for sure. And, they're trying what they can because they believe that these two witnesses, are probably helping the prosecution. And, just viewing it, they were definitely the two strongest witnesses that the prosecution had. So that's kind of how I took it, more from that angle. It's just a continuation of what we've been seeing for, honestly, weeks at this point.
Yeah, absolutely, Kelly. And there's so much to unpack here with each day. I do want to move on to after these motions, we saw the defense begin to call their witnesses. So all of the witnesses so far have been called by the prosecution. And then when you see the defense approaching them, that's cross-examination. So then we move to the defense calling their line of witnesses, which we don't have clarity on exactly how many there are just yet. But we did get through quite a few on the stand today. Many were Grand Rapids police officers, either current or retired, several of whom responded to that scene afterward. The scene, of course, after Patrick Loya had been shot by former Officer Schurr. And definitely interesting points of testimony throughout, but one that we really focused on in our early evening newscast was Captain Seaver. Is that how that was pronounced? Captain Seaver, David Seaver, current captain with the GRPD. And what we saw the defense, kind of the approach, the tackle that they made here was in outlining GRPD policy and how that played into, what Schurr did on that day and trying to prove the point that he was following the policy that he was trained under. And I'm really generalizing here, but, that was how we wrapped up today, was with him on the stand. Things that stood out to you guys about his testimony.
I think the biggest thing two big things. One is that the questions that they were asking Seaver in particular were almost counteracting what Stoughton was asked. You heard the defense at one point ask him, is a thumb the same thing as a taser in regards to poking someone in the eye? Now, if you remember yesterday, Stoughton was asked kind of a similar question, and he said, doesn't matter if it's a thumb or a taser, if you're blind, you're blind. Well, they asked kind of a different question, but in that same realm, and he answered it very differently. So you can kind of see they're kind of building their case around questions that have already been asked. But I think the biggest thing that really stands out to everyone is kind of that explosive questioning that we saw from Becker at the end, which ultimately got stopped, and we'll have to start again. But, really pounding hard on this policy. I think one of the things that he really pushed was the fact that there is no pursuit policy with GRPD. And that, that's something that the defense hit hard on with this this witness was saying, what is the policy? What is the policy? But then Becker says there is no policy. And you saw Seaver said, well, there isn't. So I think that's the biggest thing that stuck out for me. Yeah, and really honing in on that policy, we do have some from his testimony. One first talking about, when can a firearm be used? We can play that clip now.
When can an officer discharge their firearm?
So it starts with a reasonable threat of death or serious bodily injury to yourself, another citizen, or another officer, and then to present the escape of a inherently violent fleeing felony crime, and the probable cause to believe that subject poses a reasonable threat to others or officers.
And again, as we mentioned, this is what we saw was kind of harping on policy and how, that played into the actions that Schurr performed on that day. I want to get a little bit more into the rebuttal at the end that, Lauren, you were talking about, but I did want to play one more clip that kind of talked about misconceptions that I feel like the public may view when it comes to using a firearm and what a police officer here in our city is supposed to do. That was brought up, and so we can play that here as well.
And when you are training them on how to use the firearm, where do you train them to?
Yeah, so kind of a misconception, unfortunately, is shoot to wound. We train to stop the threat, and we teach to shoot center mass because that's the largest target area that people have. So upper chest, upper back, those areas, we don't train to shoot limbs or shoot the gun out of somebody's hand because the likelihood of success is not very high. So that in its easiest explanation is the preferred target areas for, but like I said, some of the drills, it's point shooting, if you will, where you're pointing, you're drawing your firearm under stress and you're firing rounds at a target. So you're not actively aiming your firearm, if that makes sense. You're not, looking through your sights, developing a sight picture, taking your time. It's under duress, under stress, and you're just trying to get a response out right away.
And I think you mentioned close quarter battle.
Yeah, so it's a term, sorry, monikers and acronyms, but all that means is that threat is probably within arm's reach of me.
And we are going to wrap up here in just a couple of minutes. I wanted to give Callie just one more opportunity. Callie, as we don't have any clips of testimony at the very end there just because it was so close to showtime for us, but watching that end, that rebuttal from Becker, from Kent County Prosecutor Chris Becker, as Lauren brought up, what was your take there on kind of those final fiery moments?
It was our first time that we were able to see how Kent County Prosecutor Chris Becker is going to cross-examine these defense witnesses. And there were other witnesses from the defense that were called today. There were 3 other GRPD officers, and then there was that forensic video analyst. And there weren't any questions, if I can recall, from the prosecution for the 3 other officers, but it was this one that, we were using the word explosive. Becker came right out because this was a traffic stop that continued into a foot pursuit. And so he came out questioning this foot pursuit policy, but GRPD does not have a foot pursuit policy. So he was really questioning on the lack of foot pursuit policy, because then he was asking, how can you train your officers on foot pursuit policy when there is nothing from GRPD that explicitly states, this foot pursuit policy. And so he also brought up, some of these national standards that were talked about from the 2 use of force experts, Stoughton and Bloomfield, and saying, how do those come into play? Because there is an organization that Cyber is a member of, and so is, as Becker pointed out, GRPD Police Chief Eric Winstrom. They're both a part of this I believe it's a national, maybe international police organization, and they do have standards on foot pursuit policies. So he was saying, you subscribe to this organization, you are a member of this organization, so how does their foot pursuit policy come into play when these are some standards that are nationally, possibly internationally recognized? And there was a lot of energy, you could say that that voices were a little bit raised. There was some times where there was some objections, and sometimes the judge had to step in. And I think we're going to see the same amount of energy exploding into that courtroom when we return tomorrow morning.
Absolutely. Callie, we thank you so much for your time. I know it's been a long day. We will cut you loose and wrap things up here. Thank you for your analysis. Lauren, anything else from you just on, those were sort of similar points that you were making, and obviously this testimony will continue into tomorrow as we've seen happen so far.
I think the biggest thing, at least from the expert's point of view, is that, there is no winning of the day. There is no, they said this, so the case is over. It really does come down to everything that's laid out. So for people who are watching, it's great to see, well, I don't want to say great, but it may be entertaining to see, these very explosive testimonies. But you have to remember that the jurors have to take all of this into account into a law and deciding whether or not the shooting is justified. Doesn't matter if, one piece of evidence stands out more than the other, but it really just comes to that justification. So, you really got to watch the whole trial to see what happens.
Yeah, we talk about kind of top moments, but as they're taking all of this and then forming, of course, their opinion that will determine how this pans out. That is going to do it for us tonight. I so appreciate you guys being here. These are long, long days for our team, but obviously a case that is really critical here in in our community. You can continue to watch our streaming coverage. Lauren is starting that each day in the early morning and continuing to anchor through the entire day, walking you through all of that testimony. We have experts that join us, and then of course we walk through top moments in our early evening newscasts where you can catch Josh and our Riley Mack and Callie Lichter, and then each night here on Evening Plus, we're sort of giving you a recap at everything that happened each day. So we so appreciate you joining us here on Evening Plus. We will be right back here tomorrow at 6:30 live, but until then, have a great rest of your evening. Thanks so much for joining us.